Community Radio. Wherever you are, we got you covered. 96.7 FM in Kigali, 102 FM Eastern Province, 101.1 FM Northern Province, 103.3 FM Western Province, and 107.9 FM Southern Province.
Good evening. This is Rwanda Beyond the Headlines. Don't be, those of you who know the program already, don't be perturbed. I know it usually comes on Sundays, but we have changed things slightly because we're honored to have some really heavyweight legal minds, and we thought we'd take advantage of while they were in the studio. So we have with us the two officers of the East African Court of Justice and one very senior judge in Rwandan judge, and who wears all manner of different hats, and he will tell us a little bit about that. We have the Honorable Justice Richard Wejuli, who is a Deputy Principal Judge in the East African Court of Justice. We have the Honorable Justice Harrison Mutabazi, who is the Judiciary of Rwanda, and we have Honorable Christine Mutimura, who is Acting Registrar, East African Court of Justice. So you can see that really, I think this is the moment to try. We'll try and ask all the questions that we'll have had. You may have heard about the East African Court of Justice, and we couldn't have better people to answer those questions. So let's, ladies first. Honorable Christine Mutimura, hello and welcome.
Thank you. Good evening.
Thank you very much. And Justice Richard Wejuli, thank you very much for joining us. And similarly, Justice Mutabazi, hello. Thank you very much indeed for joining us.
Thank you very much.
I think maybe we ought to start with how you happen to be in Kigali, all of you at the same moment. I know that Honorable Mutabazi usually are anyway, yes, but the other two are usually out of the country, wherever the court might be sitting. So it was a conference. Could you tell us something about that? Could we start maybe with you, Honorable Mutimura?
Thank you. We concluded our third annual East African Judicial Conference on the 19th of February 2025 in Kigali at the Marriott Hotel. And the theme of our conference was Justice, Ethics and Enforcement of Decisions, a Judicial Pathway for Regional Development.
That is a long one. And it's worth repeating slowly, please.
Yes.
Yeah.
Justice, Ethics, an enforcement of decisions, a judicial pathway for regional development.
Right. Now that, let me bring in Justice Wejuli, because that suggests for you to pick that theme. Why? Were these things needed, or are these things that are normally needed anyway? Why that particular theme?
Thank you, Vincent. The themes that the court picks on are really driven by the times. On this particular occasion, it's really, if you notice, one of the issues in there was enforcement. So enforcement and ethics are big drivers for justice in the region. And for us, for the court, enforcement is a bit of a challenge because we do not have an enforcement mandate in the partner states. So it was a very well, carefully selected theme in that regard. It speaks to our relevance in the partner states as a court when it comes to enforcement of our decisions. So we thought that this is a challenge we have that we must highlight in the partner states. And so when we came to Kigali, we thought this is a time and opportunity for us to drum up issues of enforcement in this conference this year.
I don't know at what time or what period of time the word challenge replaced problems that existed. So, but at somewhere, no one was talking about problems anymore. They were talking about challenges. So how much of a problem has this been for you to be able to think that it's worth doing now? Or is it, as I say, normal, really things that you keep looking at as the court changes, the court grows? Justice Smith. Please, Honorable Timur, sorry.
Thank you. So, implementation and enforcement of decisions is a challenge that is faced by all courts. But I'll speak on the East African Court of Justice. Now, the biggest challenge, as Justice Wejuli has said, is that we do not have an enforcement mechanism, or I could say a mechanism that ensures implementation of our decisions. Now, we have a treaty provision that provides that national courts will enforce our decisions. That is quite straightforward and very easy when it comes to decisions of an economic nature, because partner states are always so quick to ensure that they enforce that because it's to their benefit. But when it comes to other decisions like restoration of rights, there's a challenge. Now, the Treaty for the Establishment of the East African Community provides that every partner state should be able to uphold its obligations under the treaty. And where it does not uphold its obligations, then they shall be subjected to sanctions. However, we are not told how those sanctions will be operationalized. So as a court, we find it quite challenging to move states to implement our decisions. And as the judge said, we do not have, that is not our mandate. Our mandate is not to move states to implement our decisions, but our mandate is to make those decisions.
Honorable Mutabazi, I think this is where you come in.
Yes.
Because Honorable Mutimura mentioned essentially the lack of enforcement, which necessarily means dependence on the local courts, on the local member courts. Now, before you answer that, please do tell us I mentioned that you wear different hats in the Rwandan judiciary. If you tell us that, because I mean, it's I think it's self-evident about Justice Wejuli. He's a deputy principal judge, and perhaps the other person that those of us outside the legal system might want to know about. Also what a registrar does, and we can hear about that a little bit later. But let's hear from you first what this theme of the conference was, and starting with what you do and what role you play in the Rwanda judiciary system.
Right. Thank you very much, and I'm delighted to be hosted at the Kerry Press studios. I'll begin with what I do. As I said, predominantly I'm a judge of the High Court of Rwanda, but recently I was also tasked with working with the Inspectorate Department. So the Inspectorate Department of Rwanda also has various divisions in there. So the divisions that I'm also tasked to be the spokesperson of the judiciary of Rwanda. And on top of that, I'm also we have an association of judicial officers, the Rwanda judicial officers. So I also was elected to be the president, the incumbent president of the Rwanda Judicial Officers Association, and some other minor tasks that also attributed to, like the point person that is very much overseeing the implementation of ADR in the judiciary of Rwanda, and definitely that's why I also talk about of the interests of this conference, the 2 days conference that we had, because it very much featured the implementation of ADR, and a lot was talked about, and we gained a lot from that. So basically that is what I do on a daily basis, and very much I come to studios. I haven't been here for some time, but I was here some years back, so that is my duty. So I'm off the bench temporarily. I'm not judging, but definitely I wear a hat of a judge, definitely. So basically that is what I do.
Now, all of you combine the understanding of the East African Court of Justice and the understanding of at least the local courts represented here in the member countries. Justice Wejuli, you of course know a great deal about the justice system in Uganda and the East African Court of Justice. Now, when we talk about the theme of this conference, again, could you tell us those challenges and why it is that that theme is especially necessary now, and the possibilities as we move the discussion along, the possibilities of those becoming less of a challenge.
Thank you again. Thank you, Vincent. You see, fundamentally, when one goes to court, they go expecting to find a resolution of a grievance or a dispute. So they expect to go home with a solution. And a court decision alone, unless it's transformed into a tangible, fruit, if I call it that way, it means very little for a litigant. So what it is that, like the registrar mentioned, we pass decisions as a court, but we do not have a mechanism for enforcement of the decisions. Now, our litigants, because we're a regional court, the litigants in our court come from different parts of the partners of the region, or the different partner states. So the treaty and the rules provide that when you get a decision in your favor, to enforce it, you go and make an application in your home or partner state in which you want that decision implemented, enforced. Now, you go in Uganda specifically, you go to the High Court and file that decision, and so it is enforced through the rules that apply in the courts in Uganda for enforcement of decisions. And the same is basically, in a way, the same is what happens, what should pertain in all the other partner states. Different things come into play. There is the willingness to support that process by the partner states, but also there are some disparities, some subtle disparities in the rules in how this happens. So the pace at which this happens, but also sometimes the process through which you have to go through to get this decision that you have actualized into the benefit poses a challenge for the people who come to the courts.
That word again. Yeah.
Right.
So just sorry to interrupt, but one way of that might help to help us to understand this a little bit better is if we outline the kind of cases that the East African Court of Justice takes on. Yeah. Maybe we should have begun with that really. It's what kind of cases you do, and then we can see what challenges might arise out of trying to enforce those once the decision has been made, judicial decision has been made.
Right, that's right. The primarily the court's mandate is to deal with cases that pertain to interpretation and enforcement of the treaty. So cases that come to the East African Court of Justice are cases that touch on infraction of provisions of the treaty. There are cases, first of all, who are the litigants, potential litigants in the court. In the court, the potential litigants are partner states, state to state, in various residences of East Africa against a state, or against institutions of the EAC. Those would be potentially the litigants. So what happens is that the disputes that arise will range from trade disputes between states, disputes over infraction of principles, fundamental and operational principles of the treaty, which might be social disputes over social injustices, disputes over issues of governance, rule of law, and other civil liberties or human rights. So that is the kind of thing that happens. So if it's a trade dispute, it might be a dispute between states. So one state implementing its decision in another state might be an issue that arises, or an individual that has taken a partner state to court and gotten a decision against the partner state implementing a dispute.
Okay. So if you're listening and you've got a case against your neighbor, please don't bother. Keep it locally. Now, before we leave this rotational conference, let's talk about then the decisions were made, that what you arrived at. I mean, at the end of it, what the next conference might take on, and also let's look at the conference itself, how often it comes and why it's rotational. And so let's start with Honorable Mutimura.
So the purpose of rotating our annual conferences is, number one, to bring the court's activities closer to the people. So when you bring it, for example, to Rwanda, then you have increased participation of the legal fraternity, the members of the judiciary, civil society organizations, as well as private sector representatives. So it's an opportunity really for the nationals of Rwanda from the different, areas of practice, and these are particularly stakeholders of the court, to be able to contribute to the conversations that are being held on whether they're current or emerging issues that the court has selected for discussion.
Yeah. I was a little bit glib by saying, if you go issues with your neighbors, don't bother looking at the court. But let's look at it seriously. For individual people within East African, individual citizens of East African, how, if you want to tell them how the court serves them and why it's important, what would you say to them, and how it can engage with them?
Yes. First of all, I think that the key message to tell the locals, let me call them that way, is that Rwanda is a member of the East African community. And as a member of the East African community, then the Rwandans are East Africans. As East Africans, they stand to benefit from the programs and the activities of the community. So because of our membership to the activity, traders, for example, have had waivers to certain tariffs in the region. And I think people from the private sector have a very good understanding of what the benefits have been for them to join East Africa. But we can also look at commodities in the market. They are much cheaper than if we weren't in the community. However, with regards to the court, the East African Court of Justice is the judicial arm of the community.
Yes.
That means it is there to resolve disputes emanating from violations to the treaty. So if there's a Rwandan citizen who feels like their rights have been violated, then we have a court in Arusha that would be ready to handle these matters. However, they should be able to have a good understanding of the treaty. And we have what we call a sub-registry, a small office that is located at the Supreme Court of Rwanda, where Rwandans can go and, first of all, speak to a clerk of the East African Court of Justice, share what their issue is, and he'll be able to advise them on whether they can actually file a matter. And they can file their matter at the sub-registry.
I think we're going to come back on what it means to ordinary people a little bit on that, because this is rather important. You mentioned the commercial aspect, but of course there are others. Let's bring you in, Honorable Mutawal, because Honorable Mutimura mentioned that the benefits that the rotational conference brings, and it makes a lot of sense. You bring justice closer to the people. So let's talk about that. What else does it bring? And I would imagine you will want, no doubt, to talk about the good things, but it is also a huge effort. It is also a huge cost. But let's hear about that and understand why that cost is worth it.
Right, yes. As you said last week, that the cost is worth it, of course. But what I would say, and I would thank very much the Lord and worship on behalf of the judiciary to the EACJ, is that although you say the cost, it's not that it's only shouldered to the host country. So there's a lot that they do, that the cost sharing, and definitely we don't hear the heavy yoke on us. It's quite lighter, but it's worth it that way. So they've talked about the benefits the citizens that get here, but also the benefit from the judiciary. The first thing is that before I would think that they decide to have a rotation in a country, they will come and first see if it's capable, isn't it? So I wouldn't think if they would come in and first of all, when they were site visiting and then they saw our facilities are substandard and all that, if they would come into Rwanda. So coming in here and then they say it's been a success, it's a plus to the judiciary of Rwanda, it's a plus to the country that we can manage this. So it's also part of our visibility and knowing that we're capable, the judiciary is capable to host such, first of all, the conference, and then an eminent court like this, a regional court, to come and sit and have 3 weeks or a month, and they go on comfortably. It's a plus, a big benefit to the judicial of Rwanda, but also the country also. But definitely I'll go back to the benefits that we garnered, especially from the conference, the 2 days conference. I'll begin with that because it directly touches the judiciary. They talked about the theme, and they were talking about the enforcement of the judgments and all. It wasn't the only theme that was talked about. There were a lot of first of all, there were as I was saying, there were almost plus 250 eminent jurists, that's judges, lawyers, attorneys from around here, and even beyond East Africa, that are eminent legal scholars that were here the 2 days, and they had superb presentations that definitely we, the local judges and the judicial officers that were in attendance, definitely benefited. I will echo, I said, I'm very much keen to ADR. We had a presentation on ADR that various countries, we presented our what we do, but we had Tanzania, we had Uganda thing also present, but outstandingly, like Tanzania, they talked about what they're doing, and really we wanted to very much follow what they do. They talked about community mediation that we're also going through. You remember the judge talking about a mediator that does mediation in the night. That took us of a surprise, and it benefit, and there's a lot that happens there. So, and we're also thinking on how now we can enhance our community mediation and all that, and ADR. So these are things that you benefit because you've had people come and share the experience, and you learn from that, and this is something that you take from here. The other is the networking. Of course, there's something that they say, your network is your net worth. You know that saying. So there's nothing that you can, because how would you get the touch of everyone that is in Tanzania, Uganda, Kenya, Zanzibar, and what in that way? But you're having them here, and then you can network, and now you can have a moment to call your friend who is in Uganda. Shortly I was telling his lordship of my friend who is a retired judge in the Supreme Court of Judge. We've bonded in such forums, and they become friends, that if you needed some legal opinion from anywhere, you'd get it very fast in that way. So that is something that you can never match in the benefits that you get as a country hosting such conferences. But also to the country, definitely the 250 visitors that come in here and stay in the hotels and go buying souvenirs and all that.
Visit Rwanda.
The visit Rwanda.
Yeah.
What can you match with it, definitely? So saying the cost that it's not very much matching to what we gain this, but also to our citizens. For instance, the sessions, yesterday I was talking to the students that I usually go teach to the ILPD, and they were telling me some of them visited the sessions, and they were really very fascinated in the sessions, and they were going, so where would they see them if it's in Arusha? They were here in this way. So that's something that the benefits that we get there, but also what they said is that at least the citizens will know the types of disputes they're supposed to take to the courts, and not every dispute is supposed to be going there. So a lot that we've gotten from this, and so we're indebted to the EACJ, and we're thankful that they chose to come and have the rotational sessions in Kigali.
In Rwanda.
Yes, in Rwanda.
I was just a little bit distracted by the thought, the image in my mind of over 200 legal minds in one room, having to arrive at specific decisions. So from all of you, starting with you, Justice Wejuli, please give us an idea, give us a picture, give us really a feeling of what it's like to have all of your colleagues in the same room for however many days, or even if it's just a matter of hours. But then we'll come to the specific decisions at which you arrived. Yeah.
Well, thank you. You say we talked 250 people, 250 brains in one room, legal brains. You could think of disparity in thoughts, in opinions.
Lots of arguments.
But because the conference is driven by thematic areas, you get people to express their thoughts and opinions about issues, and that is what, like Justice Mtawaze said, that is what enriches or cross-pollinate thinking. Because we're a regional court, and I'll come back to your question of how it feels, because we're a regional court, we with a different background with partner states, different judicial systems. We sometimes face challenges of a disparity of systems. Now, you have a civil system background in Rwanda, Burundi, Zaire, DRC, has its own, unique judicial background. We have got the common law background from the other partner states. The court proceedings are predominantly common law based. But then the matters that come, the disputes that come to court originate from civil law jurisdiction. So you can imagine that dilemma. So what this conference does is to kind of harmonize the different judicial minds, and we derive consensus on some of the issues. We learn from some of the presentations by the different 250 membership that is at this conference. So that is the feeling that you get is an atmosphere of exchanging, learning, disputing, consensus. When we come to clearly, for example, some judges are from a common law background, and some of the questions we ask the litigants when they come are because of a practical or experiential knowledge gap of what happens in a civil law court. We've had occasion, opportunity to interact with our colleagues here during that conference and after, for us who remain behind, and learned certain things about civil law system. We have also shared with some of our colleagues about common law system and the court proceedings. We have exchanged with lawyers, because you see, at this conference you have the bar, the lawyers, and the judges, judicial minds. So you'll get opportunity to learn the challenges, or I use the word challenges so many times.
Yes.
You get to learn from the lawyers what their perspectives are. They'll get to understand from the judges why the thinking is as such. And so those are some of the benefits you get. It's really moving towards harmonization of different perspectives that are all intended to drive integration across the region. So really you're harnessing the benefits of diversity in that kind of setup. Yes.
Let's stay with you for a bit and have Honorable Mtimra also jump in a little bit, but let's stay with you for a bit. And in spite of all these challenges, the cases that the court handles continue to grow. So it is obviously popular. The litigants want to bring cases to the court, which presumably speaks well of you, or perhaps speaks well of desperation of the litigants. I don't know. Could you look at what, again, we're back to challenges. I'm going to, be a little bit, off message and call them problems that will bring with this heavy caseload. and what it might mean for member states, for people in the member states, individual people in the member states.
First of all, you see, for the individual person in the member state, I look at it in two ways. Who can potentially be a litigant in the court? Like we said, is a resident of the partner state. Any resident of the partner state, mark resident, not citizen necessarily. So any resident of the partner state. That means that any resident of the partner state who chooses to litigate in the court can potentially be impacted by the happenings of the court. Then that is the perspective of the court user or the video. So they will be impacted in that way. But generally, as the citizens of East Africa, the court is resourced by the partner states. It's funded by contributions from the partner states. Now, it means that you are part of the support mechanism or sitting for the court. The money comes from the citizens of East Africa. Now, what that means is that if you are meeting your obligations as a citizen and the partner state is not meeting its obligations to the community or to the court in terms of contributions, then you're going to be impacted in that you will not get justice if you're a litigant, but also the benefits of integration that come from adjudicating cases, because some of these cases are public interest litigation cases that will impact you even if you're not directly litigating in court. So if decisions are not passed in matters of environmental cases because the court cannot sit, because the partner state has not made its contribution, then as a partner, as a citizen, you can see that you're being impacted even if you're not a litigant. So those are subtle things that the citizens get to know about when we interact through, say, programs such as this, when we get platforms to create awareness about what the court does and what it's about. Those are some of the things. Citizens get empowered. They get empowered in knowledge. To know that, one, I can access the court in this respect. If I have got an issue, this is what it takes. I may not go to court against another private citizen, so I'll not waste my resources going to court and then the matter is thrown out. Or because to come to the East African Court of Justice, you do not necessarily have to have exhausted local options for court. And we know that in some of our jurisdictions, we have a challenge of basically simple thing like case backlog. Somebody might want to get their case fast-tracked, or as it is with justice, somebody might think that I'll not get justice here, so I'll get it elsewhere, I'll come to court. So the court is open to residents, even if they have not explored the local judicial options available.
Okay. Yeah. Let me, I mean, this is a really educational evening in many ways, and we could, unfortunately, we don't have a couple more hours, which would be very nice. So let me try and go back to the specific key decisions of the conference, anything that came out that you can then now just tick off and say, until the next conference, at least that's done. We talked an awful lot about the challenges, and this conference was one of the ways of meeting those challenges. So let's look at those. Honorable Mutimura, let's start with you if we may.
Thank you. So I wish to talk about the outcomes of the conference rather than decisions of the conference.
Okay.
Now, one of the...
This is the challenge problem.
Yes, so one of the key outcomes was clarity amongst participants on the role of the court as a judicial arm of the community, but also as an alternative dispute resolution mechanism. Now, when we talk about alternative dispute resolution mechanism, we are talking about mediation, conciliation, and arbitration. So, judiciaries in Africa are trying to focus more on the use of alternative dispute resolution mechanisms for purposes of resolving disputes. And the reason for this, number one, is to reduce the case backlog, but also because that they have the use of these mechanisms have been found to restore peace in communities. And it's also cheaper for the judiciaries because it's the dispensation of these matters is quite quick compared to going through the normal court processes. And one of the major outcomes of this is that exactly a week after this conference, the East African Court of Justice signed an MOU with Pepperdine University. And the purpose of this MOU is to provide capacity building to judges and staff of the court. And one of these programs that we are going to get is postgraduate programs in alternative dispute resolution for our judges mainly, which is a great achievement. And the other thing is that those enhanced multi-stakeholder engagements, and like I did mention, we have lawyers, we have private sector representatives, civil society organizations participate in the conference. Now, as a result of that conference, and like Justice Mutabazi said, the conference is a melting pot of great ideas. And this is where people come together. Sometimes this is where deals are struck. And one of the major outcomes of this conference is that we're going to have the inaugural Bar Bench Forum. The Bar Bench Forum is a forum that brings together judges and litigants of the East African Court of Justice. So we are basically going to be in one room with lawyers who bring matters to our court, and we're going to discuss the challenges that we face, number one, as a court, but also the litigants will share their challenges. But we're also going to look at opportunities for our collaboration and what we can do together to enhance access to justice in East Africa. Now, the other thing about this conference is that we had participation from regional courts, the ECOWAS Court of Justice, the COMESA Court of Justice, and from their presence, those conversations that were had about enhancing our collaboration as judicial arms of regional economic blocs. So you see, there's a lot of opportunity there. But most importantly is that from these discussions, judges are able to also contribute to the jurisprudence. New ideas come up, new schools of thought, and from that sharing of ideas, then there's a lot that we get to learn. And when it comes to making decisions, then they are more informed. And not only that, you're able to make contact with a judge from another jurisdiction to ask how they may have dealt with a particular matter. So the conference is an invaluable activity, not only for the East African Court of Justice, but also judges of national courts and regional courts. I also thought it's important that I mention that it is also a great opportunity for judges of the East African Court of Justice to also dialogue with judges from the national courts. You know, many people, even some judges, believe that matters of regional integration can only be handled by the East African Court of Justice. But judges of the national judiciaries also have a role to play. So their presence in the conference gave them a better understanding of exactly what their role is in the regional integration process.
Because these things change even for great legal minds. So
yes.
You need to remind yourself of these things.
Exactly.
Now, we're going to go to Honorable Mutabazi in a second. But before we do that, I want to ask, you mentioned the move towards finding conflict resolution methods that keep people out of the court for various reasons. So we'll go to Justice Mutabazi and find out what's happened with that in Rwanda. But before we do that, I wanted to come back to this idea of the ordinary people and the East African Court of Justice. Now, if you listening to all of you here, as I say, one does get this really quite a sense of the importance and the gravity of all these legal minds in the same place and exchange all these ideas and so on. Now, it is inevitable that the ordinary person will feel unconnected to that. So how do you connect them to that? I mean, this is a worldwide issue, actually. It isn't just in East Africa or Africa generally. So how do you make, how do you get the ordinary person to feel that this is relevant to you?
Okay. Well, what we're doing right now is part of outreach to the ordinary citizens. And I believe this radio will go far and wide and will have ordinary citizens get a better understanding on who the East African Court of Justice is, their mandate, and their role in the integration process. One other thing, we've done a number of things as a court to ensure that we go closer to the people, or that the local citizens or the East African citizens, number one, have a better understanding of our court, but can also use our court. We have a training of editors and journalists from the region. And the reason why we took it upon ourselves to actually start training them on reporting on the East African Court of Justice matters, whether it's activities or court sessions or decisions, is because we feel they have a wider reach than we have when it comes to the East Africans. So through those trainings, then we have more informative, articles or radio programs that get to the people. So the media are a very key stakeholder to the court. But also we are using the media to hold states accountable when it comes to implementation or enforcement of decisions. The other thing is that we have our sub-registries in the partner states. Well, they're found in the capitals, but we feel like that is one step in getting our court closer to the people. So we have our sub-registries in 5 partner states, but soon we'll establish our sub-registries in DRC, in South Sudan, and in Somalia. Now, the sub-registry is where our litigants in the partner states go to file their matters, but there are those we know also who cannot afford to fly to Arusha, so they can actually attend to their matters from the sub-registry. Now, we have also tried to enhance our collaboration with different actors in the region. We have the judiciaries, we have the ministries of East African Community, or ministries charged with EAC affairs. We also have the local government. So whenever there are activities, then you will usually find an East African Court of Justice exhibition table there. And that is where we have people come to us and we talk to them about the court. And we found that these have been very effective, especially for students or for just people attending some of these exhibitions. Now, one of the other things that we are trying to do is also establish information centers in our sub-registries. And you'd understand what an information center is. It is fully equipped to have, or it's a one-stop center where anyone who visits the sub-registry will be able to have all the information that they require on how the court operates. And in addition to that is that we are also trying to enhance our collaboration with different key players. I talked about the civil society organizations. They have very interesting programs, and we always try to see that we are involved in those programs so that we can have an opportunity to talk about the court. Thank you.
Justice Mutabazi, Honorable Mutimura talked about these other alternatives, methods of justice. Could you talk about that from the Rwandan perspective? And also, you talked about the benefits of the conference, and it is convincing. I'm convinced. It sounds brilliant. So then tell us again how that works into what you're trying to do in Rwanda to keep people out of the courts. And yeah.
Thank you very much. A lot is happening in the courts, and very much so, as the ECJ talked about alternative dispute resolution, but a lot is happening in the courts, and actually we no longer want to call it an alternative. By the way, we want to call it appropriate dispute resolution, because when you talk about alternative, people would think that is secondary, litigation is prime, but we would think we want this to be now the appropriate, the main. So Rwanda, the judiciary of Rwanda, but even before the judiciary,